The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. I'd like to welcome counsel as well as all of those who are watching us on our Supreme Court Live channel. Begin today's docket by asking Mr. Doug Shima, the clerk of the appellate courts, to please call this morning's case.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Wednesday, December 16th, 2020 consists of one case. Appeal number 121378, State of Kansas versus Julio Romero Fraire, Ford County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Would ask that counsel would please state their appearances for the record.
May it please the court, Peter Meharry, Assistant Appellate Defender for Julio Fraire, present and ready for argument.
May it please the court, the state appears by Assistant Solicitor General Jody Litvin, present and ready for argument.
Thank you, counsel. Court looks forward to your arguments. Mr. Meharry, you may begin.
May it please the court. This case comes before this court after my client was convicted of one count of first-degree murder, along with one count of criminal possession of a weapon. He was sentenced to the hard 50 and also a consecutive 21-month sentence for the criminal possession charge. Those charges arose out of a shooting at a club down in Dodge City. This took place several years ago, but police were responding to a call of shots fired. They found an individual who had several gunshot wounds in the parking lot close to the club, and that individual later died from those wounds. The investigation took a few turns along the way. The initial identification of the shooter was an individual by the name of Rigoberto Diaz. However, the state later turned its attention to my client, and after offering several plea deals to individuals, had a couple individuals testify at trial that it was actually my client who shot and killed the victim. So the issue at trial was identification. The defense at trial was that Julio was not the shooter. Rather, it was the individual who was first identified as the shooter, Rigoberto Diaz. And the first issue we have raised in this case deals with that very, I think, central issue to the case, and that is identification. During trial, my client was incarcerated. So he was dressed out by the jail on, I believe it was a Tuesday of trial. Mr. Diaz also was incarcerated, and he was called as a witness on Friday, and he was also dressed out by the jail. The jail dressed him in identical clothing. So they came to trial looking very much alike. Defense counsel raised this issue with the court and raised concerns about it because he felt that by having the two individuals identified as the shooter dressed alike would lend support to the state's argument that the first identification of Mr. Diaz was a misidentification of the shooter. Defense counsel moved for a mistrial, and while the district court indicated it may see some prejudice, it did not see it as a fundamental failure in the proceeding and denied the mistrial.
Mr. Meharry, was there, when you said that Mr. Diaz was also incarcerated in the same facility and dressed in the same clothing, as I read the record, I don't know that the trial court ever made that finding. Is that accurate? Where do you come to that conclusion? I had the same question. What was it, just similar clothing or was it identical clothing?
My understanding, Your Honor, and this is from, would be in the record, volume 13, starting about page 155. My understanding, it was the same clothing. They described it as a striped shirt and jeans. And as far as Mr. Diaz being incarcerated, at one point, the district court said there was no testimony that Mr. Diaz was currently in custody. So the jury didn't know, But the district court also said that, quite honestly, other than the state and Mr. Fraire, who was incarcerated, no one would know that Mr. Diaz was incarcerated. So I think there is a record that he was incarcerated. And also the defense attorney did talk to jail personnel and court personnel. And I don't think it was disputed that they were dressed out in the same clothes. The jail, there was no indication that it was intentional, rather a mix-up. For whatever reason, my client's family brought him clothes on the Tuesday. For whatever reason, jail did not allow him to use those clothes, but dressed him out in their own. So I think it is identical clothing. And I think that goes to, as I said, the central issue in this case, which was identification. And it undercuts my client's defense that he was not the shooter, that the initial identification of Mr. Diaz was not a misidentification.
Can you point to anywhere that other than your client who even noticed the fact that the clothing was similar or the same? That he appeared on a Tuesday, Mr. Diaz appeared on Friday, and apparently it was only the defendant that noticed this.
That was the record. The district court did indicate that it did not identify the problem.
Well, even counsel didn't.
Defense counsel said that it was my client. Julio brought it to his attention.
Right.
So neither the district court nor the defense attorney noticed it until it was brought to their attention by my client. I don't think that changes the fact that they were dressed in identical clothing. And as defense counsel said at the hearing, the subliminal message being portrayed here is that they do look alike. Particularly when you dress them alike, that's reinforced. And therefore, the state's argument that the initial identification was a misidentification is strengthened. And my client's defense is then undercut. And that is not based on evidence that was presented, but based on something beyond the evidence. So that's why we think it is a fundamental failure in the proceeding, because it undercuts my client's defense, not based on the evidence, but something outside of the evidence.
What features did the witness focus on in making the identification? My understanding was the focus was really on eye color, and the tattoos informed her identification.
My understanding, the initial identification did at least focus on the neck tattoos. And there was evidence in the record that both my client and Mr. Diaz had neck tattoos. So they had that in common as well. But I still think when you dress them alike, that kind of reinforces the argument that the first identification was a misidentification, because you can point to not only the neck tattoos, not only their facial features, but just having people dress alike certainly makes them look alike. And that undercuts the argument that my client was trying to make, that he was not the shooter and that this other individual who was initially identified was.
How far does this extend? Is your argument based upon the fact they were incarcerated and supplied clothing by the state? Would the same argument exist if it just happened that a small town, your clothing options, purchasing options are limited. And it just happens that these two people bought the same shirt, show up in court with the same shirt on. Would there still be a basis for this argument, or is it requiring the action of a state actor part of this?
I think it doesn't necessarily require the action of a state actor. I don't think it necessarily is dependent on the fact that it was the jail that dressed both these individuals out in the same clothing. I think if you have two individuals that come into court dressed identically in a case where both have been identified as a shooter and identification is a central issue, I think that is a problem, regardless of whether or not it's the jail or just happenstance, because it undercuts what the jury is doing. The jury is there to weigh the evidence. And if you bring into the fact that they dress alike and look alike, you're kind of adding something to the jury's consideration that is beyond the evidence. So I think the fact that the jail did it, and there was no indication that this was intentional. The defense attorney said, I didn't find anything to indicate that. Rather, it was a mix-up. But the impact is still the same regardless. The impact is still that you have the individual first identified as a shooter coming into court looking exactly like my client did a couple days before.
Why doesn't that actually help the defendant? If he's arguing that this was a misidentification, it would seem to me that might help.
Your Honor, I don't think it helps because when you look at the people who are making the identifications, the two individuals that identified my client were his friends and acquaintances, the people he was with that night. So they would not make a misidentification. They were at the scene with my client. That was their testimony. So they wouldn't make a misidentification. The identification of Mr. Diaz was by someone who sort of knew them or knew him. She testified that she had seen him a few times and believed that he had, I think the way they essentially got the identification to a name was she thought he had some gang affiliation. So her identification isn't like my client's identification, which were by friends, people who would know him, people who wouldn't make a misidentification. So I think it does undercut the identification of Mr. Diaz and doesn't do anything to undercut the identification of my client.
Do you have any authority where this particular issue has been raised either in our jurisdiction or any other jurisdiction?
Your Honor, I did not find anything in my research where you had these circumstances. This seems somewhat unique. I know defense counsel mentioned he had never had this issue before, but I have not seen anything where two individuals, both identified as the shooter, came to court looking alike. I just did not find anything with those unique set of facts.
Okay.
It's probably never gonna happen in my legal career again, I would guess. This just seems very random, but I don't think that from our perspective undercuts the damage it did to my client's defense at trial. So we would ask this court for that reason to reverse and remand this matter because we believe a mistrial was warranted.
I just
I'm
have a
almost
quick
done.
question.
I'm sorry, Your Honor.
I just have a quick question. You articulated the 2 steps necessary in a mistrial. The first one is whether prejudicial conduct created a fundamental failure in the proceeding. And it seems like your argument is that the facts that support that are the state subliminally suggested that Diaz looked like defendant. So am I missing something? You're equating the subliminal message is what supports the fundamental failure in the proceeding. Is there anything I'm missing?
I think the fundamental failure is that Mr. Diaz walked in looking and dressed the same as my client. So I do think that does send a message to the jury that there is a reason why there was a misidentification, the reason why the witness misidentified Mr. Diaz. So I think it is, I guess, subliminal, if you will, but it is certainly something the jury was in the jury box when he went to the witness stand. So it was front and center for them that he was dressed identically to my client. And that I think is the fundamental failure because that is not evidence. Dressing an individual alike so that, the identification of that individual becomes questionable, I don't think is something that should happen. And it's something outside of the evidence. It's something for the jury to see and consider, but it's, outside of the evidence. So it is a fundamental failure because it undercuts my client's defense.
Counsel, was there anything particularly unique about this clothing?
The way they described it was a striped shirt and jeans. So I don't know, they didn't go into any detail beyond that. And that, striped shirt and jeans is not unique. But the testimony still was, it was the same clothing that Mr. Diaz wore that the jail had given to my client a couple days before. If there are no other questions, I see my time is out, and I would ask this court to reverse because we believe a mistrial was warranted, and I would submit the remaining issues on the brief.
Thank you, Mr. Meharry. Ms. Litvin?
Good morning. May it please the court. The state appears by Assistant Solicitor General Jody Litvin. I'll go ahead and pick up with issue 1. Our position is that the district court properly denied the motion for mistrial, and our argument here is essentially that there was no prejudicial conduct that caused a fundamental failure here. The possibility of prejudice, or as Justice Standridge was saying, the mere, subliminal message that the jury might have noticed the two in the same or similar clothing. And I'm not sure by the record, they kind of say same and identical clothing off and on. So I'm not sure if it was identical clothing, but we just don't believe that that rises to the level of prejudicial conduct that causes a fundamental failure, making it impossible to proceed with the trial. I didn't really have any further presentation unless this court has questions on any other issue.
Is there any evidence as to how they ended up wearing the same or similar clothing? Again, looking at the record and what the judge found, he found that there was really no showing that Mr. Diaz was incarcerated, that only a couple of individuals would have known that. But again, that doesn't necessarily state that he was. Anyway, is there any information that or anywhere in the record that indicates that he was and this was the same clothing? I just couldn't find it when I was looking for it.
The most I have is what comes from the district court's factual findings and what comes from defense counsel saying that maybe his uncle was turned away from giving him the defendant clothing, but that's as much as I have as well. There is nothing on the record explicitly stating that Mr. Diaz was in custody, but I think we can infer based on the district court and the defense counsel's statements that he was, and that somehow he received this clothing from the jail, which just happened to be the same clothing that the defendant wore on Tuesday of trial. And I can't account for why he was dressed differently every other day, and then the jail staff didn't allow him to receive clothes on that Tuesday. But again, I think it's important that this was not anything that was intentional on the state's part, and defense counsel didn't have anything to point to any wrongful or intentional act by the jail or the state. And then the district court reaffirmed that as well. It just seemed like a mistake in the clothing. And as far as I can tell, it was just a polo shirt and either blue jeans or gray jeans. Nothing distinctive about it. It didn't appear to be a neon colored shirt or anything flashy or noticeable. And importantly, the district court also held that there's no evidence that the jury even noticed at all. So had there been comments by the jury or something said, or even if either party or the district court had noticed, I think this would have more teeth here. But the fact that no one but the defendant noticed and nothing really was particularly distinctive about the clothing, I just don't see the actual prejudicial conduct that can get to a fundamental failure of the proceeding. And as Justice Stegall said, this cuts both ways. So as far as certainly having the potential to help the state, it had the potential to help the defendant as well had the jury noticed. So I think that it also could have bolstered his defense in that Mr. Diaz was the actual shooter. Look at how similar these two men look.
Changing to a different issue, as I understand it, you concede that the trial court erred in imposing lifetime post-release supervision for the first-degree murder conviction. And you suggest that a remedy for that would be to allow a nunc-pro-tunc order. The difficulty with that is that under our case law, nunc-pro-tunc orders will actually, under the statute, are to create or to correct clerical mistakes. where this is more than a clerical mistake. It appears this is what the trial court intended to do, so that there was a substantive mistake. So all of that is a prelude to this question. Is it appropriate for us just to vacate that order, that portion of the order? And does that accomplish what needs to be done here?
I think yes, because I guess that would make the sentence no longer illegal if you vacated the illegal portion of it. But as far as getting the change made from lifetime post-release to parole, I'm not sure if you'd have to have a resentencing to do that. But I think if you did vacate, if this was vacated, it would take the illegal portion of the sentence away.
And if we would remand with directions to the trial court to vacate, would that create the paper trail to make sure the Department of Corrections had that? I think that may be the point you were trying to get to.
Yeah, I think that, yeah, maybe vacate and then, yeah, to impose parole instead of lifetime post-release, because I guess it is a substantive, check mark on a box. I mean, it's really, it's kind of both. It's the portion, either parole or lifetime post-release is really just one of the options to check on a box. But yeah, I think vacate, if this court remanded with specific orders to vacate that and impose parole.
And is it your position the defendant would not need to be present for the trial court to impose parole?
If there's going to be a remand, and I don't know, I mean, I would say safe side, have them be there. Just because a non-protunct is just, like you said, a clerical order, Your Honor, and that wouldn't involve any new hearing. But I guess I would hesitate to say that the defendant would not need to be present if there was a remand.
Okay. Other questions? All right, thank you, Ms. Litfin. I don't know if you needed any time to wind up or if you were complete.
I don't, Your Honor. Thank you. I would just submit the rest of the issues on the brief and ask you to affirm the conviction in this case.
All right, thank you. Mr. Meharry, you reserve 3 minutes.
Thank you, Your Honor. I didn't really have anything in addition. The one thing I would say with regard to the sentence, I do think it would need to go back. It's more than a clerical error. So I do think it needs to go back for resentencing. And I do think at resentencing, my client would need to be there. Beyond that, like I said, I don't have anything further unless this court has other questions.
Any other questions? Thank you both, counsel, for your arguments this morning. We will take this appeal under advisement and court will be in recess until 11 a.m. this morning. Thank you.